respected Chair, Professor Mesbah Salehi, Dr. Justice Soyed Rafat Ahmed, the Honorable Chief Justice of Bangladesh, Honorable Judges of the Appellate Division and High Court Division of the Supreme Court of Bangladesh, Professor Muhammad Abdul Rahim, Convener, Justice Muhammad Ibrahim Trust Fund, and ladies and gentlemen present, a very good afternoon. I am deeply honored and humbled to be entrusted to deliver lecture of this year in Justice Muhammad Ibrahim Memorial Lecture Series. As you are all aware, and Professor Abdul Rahim also presented the life and contribution and achievements of Justice Muhammad Ibrahim. As a lawyer, as a judge of the High Court of East Pakistan, as Vice Chancellor of University of Dhaka, and as a law minister of then Pakistan. Not only that, Professor Abdul Rahim also mentioned in his brief case that he sacrificed his career to a great extent for the political goal, for the welfare of the people, and he actively participated the non-cooperation and non-violence movement under leadership of Mahatma Gandhi and Khilafat movement under the leadership of Maulana Muhammad Ali and Maulana Shaukat Ali. So, my feeling was mixed when I was approached to deliver lecture this year. It was a feeling of being honored as well as I am afraid of the task. And especially compared to the esteemed speakers of previous lectures in this lecture series. My feeling is that I always feel it, and I especially feel it when I was approached to deliver lecture, that I am a humble student of constitutional law. And so I have tried being fully conscious of my limitations. I have prepared a lecture, some parts of which I will try to place before you now, and I will skip many parts because you have the booklet. And furthermore, I need not place everything because I think a write-up is not worth reading if it does not leave room for the readers to read between the lines and beyond the lines. So you will read it for yourself, and your advice, your criticism, if you spend your time, valuable time, and comes to my notice, I will try to be more correct in this regard in future. I am placing very few portion of this write-up. There have been, my subject was very broad when I was approached, because it is the objective of this memory trust fund. That is law, humanities, and liberal arts. It's a very broad subject, and it is impossible to address these all areas within the limited time frame of the lecture. So I have worked out my own topic, and that is constitutional and legal doctrine of rule of law. There have been, I am now reading from this, a selected portion. There have been frequent attempts to lay down a universally acceptable definition of law. But consensus of legal experts is more or less like that. No such rigid definition could be given. Jacques Rousseau in the Social Contract said, "But what after all is law? When I say that the object of laws is always general, I mean that law considers subjects en masse and actions in the abstract, and never a particular person or action. On this view, we at once see that it can no longer be asked whose business it is to make laws, since they are acts of the general will, nor whether the prince is above law, since he is a member of the state, nor whether the law can be unjust, since no one is unjust to himself, nor how we can be both free and subject to the law, since they are but registers of our wills." Law in its generic terms is a set of rules of action or conduct prescribed by law-making authority having binding legal force. The body of rules which must be obeyed and followed by subjects is law, disobedience to and violation of which follow legal consequences. In respect of definition of law, from John Austin and Jacques Rousseau and Thomas Aquinas, Bentham, and there are various ways of defining law. Friedrich Nietzsche rejected the principle of equality, morality, and believed that law emanates from the will to power. No place of morality here, according to Friedrich Nietzsche. Law emanates from the will to power and cannot be labeled as moral or immoral. When the law is seen purely as a set of rules, one may lose sight of the social and moral dimensions as its purpose. Literature and history, for instance, provide invaluable perspectives of human behavior, motivations, and the consequence of legal decisions. Victor Hugo's La Miserable is an exemplary work that underscored these points. In the story of Ja Valjean, we see how strict legal enforcement represented by Inspector Jammer conflicts with moral redemption and human compassion. Hugo's novel highlights a fundamental question that every legal practitioner should consider. Should justice be blind to human sufferings? In view of myriad definitions, and interpretations of law, the 20th century English poet Auden significantly wrote the poem Law Like Love, a stanza of which is as follows. "Law, says the judge as he looks down his nose. Speaking clearly and most severely, law is, as I have told you before, law is, as you know, as I suppose, law is, but let me explain it once more. Law is law." Unquote. And there are different philosophical foundations of law by various jurists. In our constitution, the legislative power vests in Parliament, Article 65. apart from the enactment of the Parliament. There is Article 93 conferring power upon the President to promulgate ordinance. And apart from the Act of Parliament and ordinance promulgated by the President, our Constitution contemplates another law, another source of law. That is in Article 111 of our Constitution, law declared by the Supreme Court. That is law declared by the Appellate Division and High Court Division. Supreme Court, our composite court, comprising Appellate Division and High Court Division. So, law is declared by our Apex Court. That is also. And our Constitution in Article 158 defines law in this manner. Law means any act, ordinance, order, rule, regulation, bylaw, notification, or other legal instrument, and any custom or usage having the force of law in one. Rule of law. In the process of legal development, the concept of rule of law came into being. The rule of law is a legal principle of general application sanctioned by the recognition of legislative and executive authorities and interpreted and safeguarded by judiciary. The rule of law, sometimes called the supremacy of law, provides that decisions must be made by the application of known principles of laws without the intervention of discretion in their application. In any democratic society, the concept of rule of law is fundamental to ensuring justice, accountability, transparency, and fairness in the governance. Study of rule of law invariably attracts the name of A.V. Dicey, who in his classic treatise An Introduction to the Study of the Law of the Constitution laid down the groundwork for modern democratic systems, emphasizing the laws should govern a nation, not arbitrary decisions by individuals in power. Three basic elements in Dicey's concept of rule of law are absence of arbitrary power, meaning no man is above law and the person in the authority do not enjoy unfettered, arbitrary and discretionary powers. Equality before law. 2. 3. Individual liberty. And no arbitrary power. All powers are rooted in and sourced from the express sanction of law. That's why in courtroom also we frequently argue that whenever a government functionary or statutory body's action is in challenge, they have to show we have done it in this statute, we have been conferred, expressly conferred with this statute. They have to show it. Unless they can show it, their act is without lawful authority. Unless express conferment of power upon an authority, nothing an authority can do. But for citizens like us, unless express prohibition by any law is there, nobody can say me that you can do it. I can do it. Difference is that for authority, for executive, express conferment of power must be there by law. And for citizens, to prevent a citizen from any act, express prohibition in law must be there. আইনে বাধা না থাকলে সিটিজেন সব করতে পারবে, আইনে ক্ষমতা দেওয়া না থাকলে সরকার বা অন্য কোনো অথরিটি কিছুই করতে পারবে। দ্যাট ইজ দ্য gist and essence and spirit of rule of law. Dicey's thinking was clear. If anyone, you or I, is to be penalized, it must not be for breaking some rule dreamt up by an ingenious minister or official in order to convict us. It must be for a proven breach of established law of the land. And it must be a breach established before the ordinary courts of the land. I emphasize the word ordinary courts of the land, not a tribunal of members picked to do the government's bidding, lacking the independence and impartiality which are expected of judges. Thus, no one is above the law, and all are subject to the same law, administered in the same courts. The first is the point made by Thomas Fuller, 1654-1734, and he said in 1733, at the back end of his life, "Be you never so high, law is above you." Compared to Dicey, Thomas Fuller, Universal Declaration of Human Rights, later other international instruments on human rights, women's rights, children's rights, these are recent phenomena. And summarizing all this, our Honorable Chief Justice, Dr. Justice Soyed Refat Ahmed, in his write-up, Popular Will and the Constitutional Ecosystem, rightly concluded, quote, two basic requirements, that is, respect for the sovereign will of the people and belief in the organic nature of the Constitution, become fundamental for upholding the rule of law. That this is the true embodiment of the cherished hopes and aspirations of the people, there is no doubt. There is equally no doubt that the constitutional courts in this country remain committed to fortify a liberal and progressive constitutional order in which our citizens shall be assured of effective protection of their guaranteed rights, and we all will prosper in freedom. Unquote. Constitution, constitutional law, constitutionalism, and rule. Four distinct things closely interlinked: constitution, constitutional law, constitutionalism, and rule. A constitution is sometimes defined as the fundamental law of a state, containing the principles upon which the government is founded, regulating the division of the sovereign powers, and directing to what persons each of these powers is to be confided and the manner in which it is to be exercised. Constitutionalism is the antithesis of arbitrary powers. Constitutionalism is the antithesis of the arbitrary powers and connotes limited government. As I tried to say earlier, unless express conferment of power, authority government can do nothing. So constitutional government is always limited government. Constitutionalism is antithesis of arbitrary power, unfettered power. Constitutionalism and constitutional government not only recognize the need for governmental power, but also insist on the limitations on the power of the government. Limitation and decentralization of the governmental powers, independence of judiciary with power of judicial review, rule of law, separation of powers, inclusion of the basic human rights in the Constitution, free and fair election for forming the representative government, and transparency and accountability of the government, are basic elements of constitutionalism. A constitution is not merely the outline of the governmental structure. It is the embodiment of the hopes and aspirations of the people cherished all the years and includes the nation's high and lofty principles and people's life philosophy. A constitution is framed not for a brief span of time to meet the needs of contemporary period. It is designed for times to come. The interpretation of constitutional expressions has necessarily to receive a progressive construction in the light of the scheme and objectives enshrined in the Constitution. The American Supreme Court observed, we must never forget that it is Constitution we are expounding. The Canadian Supreme Court observed, the task of expounding a Constitution is critically different from that of construing a statute. A statute defines the present rights and obligations. It is easily enacted and as easily repealed. A constitution, by contrast, is drafted with an eye on the future. Once enacted, its provisions cannot easily repealed or amended. It must therefore be capable of growth and development over time to meet new social, political and historical realities often unimagined by its framers. The judiciary is the guardian of the Constitution and must, in interpreting its provisions, bear these considerations in mind. The rule of law is the most subjective and value-laden of all constitutional concepts in our Constitution. In Bangladesh versus Ibrahim, the appellate division said, the expression of rule of law has a number of different meanings and corollaries. Its primary meaning is that everything must be done in accordance with law. In other words, it speaks of rule of law and not of men, and everybody is under the law and nobody is above the law. The other meaning of the rule of law is that government should be conducted within a framework of recognized rules, and Constitution is the embodiment of the supreme will of the people setting forth the rules and principles. But the most important meaning of rule of law is that the dispute as to legality of the acts of the government are to be decided by the judges who are independent of the executive. In a rule of law, the manner of exercise of power is just, fair and reasonable, and not unreasonable, capricious or arbitrary, leaving room for discretion. It's very important. Frequently, especially in our rich jurisdiction, we have to argue and judges inquire on due process of law and procedural due process. So it is, what is that? End justifies the means in rule of law, not that. In a case of stealing a candle, it cannot be defense. My lord, I stole it for reading Bible. That is no defense. Stealing a candle still remains an offense, criminal offense. So, both manner, process, procedure and end result, end product are important, equally important for our rule of law. The evil state of affairs of lawlessness, in contrast to rule of law, has been portrayed in Dicey's book in following words. Dicey's সেই বিখ্যাত বইয়ে বলা আছে, When Voltaire came to England, and Voltaire represented the feeling of his age, his predominant sentiment clearly was that he had passed out the realm of despotism to a land where the laws might be harsh, but where men were ruled by law and not by caprice. He had good reason to know the difference. In 1717, Voltaire was sent to Bastille for a poem which he had not written, of which he did not know the author, and with the sentiment of which he did not agree. What adds to the oddity in English eyes of the whole transaction is that the regent treated the affair as a sort of joke, and so to speak, shafted the supposed author of this satire. I have seen on being about to pay a visit to a prison when he had not seen. In 1725, again 1717, and in 1725, Voltaire, then the literary hero of his country, was lured off from the table of a duke and was thrashed by lackeys in the presence of their noble master. He was unable to obtain either legal or honorable redress, and because he complained of this outrage, paid a second visit to Bastille. Unquote. So, absence of rule of law engenders these kinds of atrocities and arbitrariness. Law in the context of the rule of law does not mean any law enacted by the legislative authority, howsoever arbitrary or despotic it may be. What is a necessary element of the rule of law is that law must not be arbitrary or irrational, and it must satisfy the test of reason, and the democratic form of the polity seeks to ensure these elements by making the framers of the law accountable to the people. I will try to say some words in rule of law under Bangladesh Constitution, under our Constitution. And before going to that, the nature and character of our Constitution has to be kept in mind. Because in Indian subcontinent, comprising our Bangladesh, India and Pakistan, the journey of constitutional history started after defeat of First Indian Independence War, if I rightly say. And British colonial rulers termed it as Sepoy Mutiny in 1857. After defeating Sepoy Mutiny or First Indian Independence War in 1857, Government of India Act 1858 was passed in British Parliament. And by that enactment, British Empire took over the Indian colony from East India Company. We have seen in our experience nationalization many private enterprises, and it was nationalization of a colony from East India Company to British Raj. And Indian and Pakistani constitutions are constitutional and legal development of Government of India Act 1858, not we. And now I will read from this below. Sorry, I am a courtroom lawyer. So after some sentence, my lord, I habitually pronounce because my lords are sitting in front. If one is asked to describe the genesis of Bangladesh in one sentence, the answer would be like this. The demand for autonomy of the people of Bangladesh, when denied, took the shape of movement for self-determination, which they fought for and achieved at the cost of blood and sweat of millions, and most painfully at the cost of honor of millions of our women. The dream of our people of a meaningful democracy was reflected in the constitution adopted within a year of independence. The constitution, our constitution, is not the outcome of a negotiated settlement with a former colonial power, not drawn up with the concurrence or approval of any external power. It is a fruit of a historic war of independence, making it a class apart from other constitutions of comparable descriptions. In our constitution, the people feature as the dominant actors, and it is truly a manifestation of what is called the people's power. So, our constitution making process was preceded by a prolonged history over the years and centuries even. This process, our constitution making process, was not confined to the sittings, sessions, committee meetings, drafting, debates, etc. of the Constituent Assembly. The preamble of our constitution is a unique feature which reflects the precise historic struggle for national liberation. In the words of the preamble of our constitution, not full text of preamble, certain parts, we the people of Bangladesh, in our Constituent Assembly, do hereby adopt, enact, and give to ourselves this constitution. Further pledging that it shall be a fundamental aim of the state to realize through the democratic process a socialist society, free from exploitation, a society in which the rule of law, fundamental human rights and freedom, equality and justice, political, economic and social will be secured for all citizens. Egulo bole in our Constituent Assembly, this 18th day of Kartik, we do hereby adopt, enact and give to ourselves this Constitution. So the preamble makes it abundantly clear that whatever rights have been ensured in the Constitution, including the fundamental rights, are not any grant, charity from any superior authority, but it is the achievements of the people of Bangladesh. That's why in a case proceeding, when the learned judge asked me, yes, suppose we accept your submission. If we grant it, will it not open floodgate? My answer, by you of very respectful submission, was that who are you, your lordships, to open or shut the floodgate? It is the people of Bangladesh. Our rights as enumerated in Part 3 of the Constitution. Article 107 once declared, any law inconsistent with the Constitution is void to the extent of inconsistency. Part 3 dealing with the fundamental rights, enumerating fundamental rights from Article 26 through Article 47. Further in Article 26 declared that no law will be passed which is inconsistent with the rights given in this part, and if any law is inconsistent with rights given in this part is void to the extent of inconsistency. That is the most important. So, Article 7, conferring supremacy of the Constitution. Part 3, the fundamental rights. These are the most important part. And then subsequent parts regarding independence of judiciary. Article 65, elected parliament for ensuring representative government, and election commission for ensuring free, fair and inclusive election to form a representative, truly representative government. These are the most important part of our constitution. So, in Anwar Hussain Chaudhary versus Bangladesh, Justice Badrul Haidar Chaudhary wrote this question. Ours is an autochthonous constitution. Autochthony in its most common acceptance is the characteristic of a constitution which has been freed from any trace of subordination to and any link with the original authority of the parliament of the foreign power that made it. The aim is to give to a constitutional instrument the force of law through its own native authority. A factual autochthony is generally achieved after a revolution. And that revolution was our liberation war. And eta amar kotha na, eta holo Anwar Hussain Chaudhary versus Bangladesh, 41 DLR AD 165 1989 PLD AD special issue 1. In view of the supremacy of the constitution, I will skip it. Our courts cannot enforce any law which is in conflict with constitution. In Marbury versus Madison, Chief Justice Marshall laid down the constitutional principle of written constitution that no court invested with judicial power can give effect to a provision of law ignoring the provision of the Constitution. In our jurisdiction, in view of the provision of Article 7 of the Constitution, the view taken by Marshall CJ in Marbury versus Madison is no longer a matter of constitutional principle, but it is a positive constitutional mandate to every court and tribunal in Bangladesh entrusted with the power of adjudication. By virtue of Marbury versus Madison, which was a matter of constitutional principle laid down by the Supreme Court to be followed by the courts, in our constitution, by virtue of Article 7, we need not any judicial pronouncement to follow this, that no law inconsistent with the constitution can be enforced. It is in our constitution. Part 2 of the constitution containing articles 8 through 25 contemplates fundamental principles of state policy. And here I will mention only one, Article 11. The Republic, in preamble it is there, and Article 11 again reiterates, the Republic shall be a democracy in which fundamental human rights and freedom and respect for the dignity and worth of the human person shall be guaranteed, and in which effective participation by the people through their elected representatives in administration at all levels shall be ensured. And so part 2 of the Constitution, Article 11 is also placed in part 2, 8 to 25. It contains the spirit and letters, of the doctrine of rule of law. Part 3 of our Constitution, Article 26 to 47, enumerates the fundamental rights which the citizens of Bangladesh, all the fundamental rights, and some of the fundamental rights, not only citizens of Bangladesh, the persons for the time being in Bangladesh, available to them also. And if we discuss and analyze these fundamental rights, possibly, as I could understand with my limited understanding, that we can broadly categorize the fundamental rights in three categories. Some are absolute, some are qualified, and some are further qualified. There are some rights like Article 27, Article 28, Article 29, Article 31, Article 27, equality before law, 31, 28, prohibition against discrimination on the ground of sex, place of birth, religion, etc. Article 29, equality of opportunity in public employment. Article 31, equal protection of law. These are, and some like this, safeguards against arrest and detention, Article 33. These are absolute rights, without any prefix. But some rights, freedom of movement, Article 36, freedom of assembly, Article 37, freedom of association, 38, freedom of speech and expression and press, Article 39, protection of home and correspondence, Article 43. These are qualified rights. Why qualified? Because these articles starts with the words subject to reasonable restrictions imposed by law. Restrictions cannot be imposed by executive order, by law. And not only by law, it has to be reasonable. If somebody challenges that these restrictions, my right to assembly, my right to form association has been restricted by this law, but this restriction is not reasonable. If it is challenged under the power of judicial review, our Supreme Court will examine whether it is reasonable or not, and then it has to be shown that this restriction is reasonable. So, the earlier some 27, 31, 28, 29, these are absolute rights, no restrictions. Second group is subject to reasonable restrictions imposed by law. These are qualified rights. And third group is there, right to profession or occupation, Article 40, freedom of religion, Article 41, rights to property, Article 42. These are further qualified rights. How and why? Because these rights started with the words subject to restrictions imposed by law. Subject to restrictions imposed by law. এই ল যে রেস্ট্রিকশনটা ইম্পোজ করলো সেটাকে রিজনেবল হওয়ার কোনো দায় নেই. These are further qualified rights. We can compare it with First Amendment, Amendment 1 of the Constitution of the United States of America. What is there? I mean, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. এগুলো করবেই না, করতে পারবে না কংগ্রেস। আর আমাদের হলো বেশ কিছু রাইটে কিছু নাই, তারপরে হলো সাবজেক্ট টু রিজনেবল রেস্ট্রিকশন ইম্পোজ বাই ল, তারপরে আছে সাবজেক্ট টু রেস্ট্রিকশনস ইম্পোজ বাই ল। এখন এখানে প্রায় যেটা হয় যে ইন দ্য নেম অফ reasonable restrictions, unreasonable restrictions are imposed. And when it happens that law does not pass the test of reasonableness of law as law is meant in Article 31. Now, I will go to another point. Article 28 provides no discrimination on the ground of sex, religion, place of birth, etc. And Article 29 guarantees equal opportunity of law in public employment. Both Article 28, in clause 4 Article 28, provides exception for making special provision for women or children or for the advancement of backward section of citizens. Article 29 also making special provisions 3A in favor of any backward section of citizens. Exceptions are provided in Article 28 and 29. Backward section of citizens is not defined in Constitution. Nowhere. Recently, in a case, যখন রাস্তা টালমাটাল জুলাই মাসে, তখন যে না এটা যা হওয়ার আমরা খুবই মানে এই উচ্চ আদালতের বাইরে কিছুই করে উচ্চ আদালতে করবে এবং উচ্চ আদালত করার পরেই করছে। উচ্চ আদালত তো ওই মানে তত্ত্বাবধায়ক সরকারকে আলট্রা ভায়াস বলার পরে 15th অ্যামেন্ডমেন্ট করে সেটা ঢুকে এখানে বলি যে ওখানে হবে। এবং সেখানে আমরা দেখলাম বলা হলো যে আর্টিকেল 104 আর্টিকেল 104 পাওয়ার টু ডু কমপ্লিট জাস্টিস, স্পেশাল পাওয়ার ইন দ্য অফ দ্য অ্যাপিলেট ডিভিশন, সেইটাকে দিয়ে আমরা করলাম কি ফ্রিডম ফাইটার্স 5% আর 5% খেয়াল নাই যে প্রতিবন্ধী এবং by no stretch of imagination or wisdom of constitutional law, freedom fighters cannot be termed as backward section of citizens. And when doing this, being conscious of this, it was said that we invoked Article 104. We invoked Article 104 for doing complete justice. We did it. But Article 104 is an extraordinary power conferred by the Constitution. In other words, conferred by the framers of the Constitution upon the appellate division for doing complete justice. This power cannot be invoked to undo any express provision of the Constitution. This power cannot be invoked to escape any express provision of the Constitution. Because in invoking Article 104 for doing complete justice, the court cannot be wiser than the framers of the Constitution, than the power givers. Now, I will skip other parts. I will come to this regarding freedom of expression. It is very important. It was important for erstwhile Bangladesh. It was important in Pakistan period. Still, it is important. So, I will read a portion on this. Article 39 guarantees freedom of thought, conscience, speech, and press. Freedom of thought is absolute because no subject to here. মনে মনে চিন্তা করলাম কিভাবে কন্ট্রোল করব, বাকিটা সাবজেক্ট। The discretion to impose restriction in this article is very wide. We have seen it in recent past. And very often this discretion is abused from the bottom to the highest level. It is not only in Bangladesh, but in many developing and underdeveloped countries where constitutionalism and democracy are not well established, and resultantly where the rule of law is not in sound practice. For exercising freedom of speech and expression and freedom of press, harassment, torture, detention, etc. In this regard, we can profitably share experience of legendary legal luminary of India, Ali S. Noriman, in his book, God save the Honorable Supreme Court. God save the Honorable Supreme Court. This fact was dramatically brought home to me when I attended Commonwealth Law Conference in Kuala Lumpur, Malaysia, way back in 1999. In the presence of the country's Prime Minister Mahammad, a delegate who was a judge in Malaysia's Court of Appeal, now retired, declared in a crowded hall with over 500 delegates in a loud voice, "Our written constitution guarantees freedom of speech." And then, after a long pause, he continued in a much softer tone, "But no freedom after speech." These were not flippant words, but once wisely and deliberately chosen. We need to ponder over it. Freedom after speech, that in essence is what the freedom of speech is all about. Now I will come the Constitution as originally adopted was a democratic constitution in 1970. Within the meaning, democratic within the meaning of for provision of representative government, though with some fundamental limitations and defects, most prominently in identity of the citizens of Bangladesh, Article 6 of 1972 Constitution, where it said, "Amader জনগণ বাঙালি, সমস্ত দেশের জনগণ বাঙালি." Subsequently, by amendments, the Constitution was turned into a document permitting autocratic rule. The most devastating effect on the democratic character of the Constitution was brought in by the Constitution 4th Amendment Act 1975, passed in January 1975. This amendment transformed 1972 Constitution beyond any resemblance with the original. The multi-party parliamentary democratic system was replaced by one-party autocratic form of government, which was an apology of a presidential form, as the normal checks and balance of a presidential form of government was absent. By this amendment, the president became the sole repository of judicial, executive and legislative power. The independence of judiciary was totally destroyed, which would form a comparison of the original provision of 1972 Constitution and the amended provision after the 4th Amendment. And fundamental rights. Article 44 in 1972 Constitution, there was a right that to enforce fundamental right, make petition to the High Court Division is also a fundamental right. It was there, the right to move the Supreme Court in accordance with clause 1 of Article 102 for the enforcement of the rights conferred by this part is guaranteed. It was in 72 Constitution. By 4th Amendment, the original Article 44 was substituted as follows. Parliament may by law establish a constitutional court, tribunal or commission for the enforcement of the rights conferred by this. এই যে রিট পিটিশন আমরা বলি, বহু চর্চিত, এমনকি সিভিল ক্রিমিনাল মামলা করার সময় মফস্বলতে যখন আসে একটা রিট করা যায়, মানে হাইকোর্টে যাওয়ার সবই, এটা ছিল না, 4th অ্যামেন্ডমেন্টে একেবারেই তুলে দেওয়া। বলা হলো যে এরকম একটা ট্রাইব্যুনাল বা কোর্ট করা যেতে পারে, পার্লামেন্ট আইন করে করতে পারে, সেটা করেও নেই, করার সুযোগও হয়। In 1972 Constitution, Article 95, Clause 1 provided, the Chief Justice shall be appointed by the President and the other judges shall be appointed by the President after consultation with the Chief Justice. This was in 1972 Constitution. Chief Justice shall be appointed by the President and other judges shall be appointed by the President in consultation with the Chief Justice. 4th Amendment ki kora holo, amended as 95(1). The Chief Justice and other judges shall be appointed by the President. 96 Clause 2 তে ছিল removal of judges. সেখানে ছিল a judge shall not be removed from his office except by an order of the president passed pursuant to a resolution of parliament supported by a majority of not less than 2/3 of the total number of members of parliament on the ground of gross misbehavior or incapacity. এখানে কি করা হলো? By 4th Amendment, clause 2 was substituted as under a judge may be removed from his office by order of the president on the ground of misbehavior or incapacity. Article 116 ছিল কি? The control of judiciary. আমি সংক্ষেপ করছি। এখানে Article 116 of the Constitution, it is the most important for independence of judiciary. Our learned judges, honorable Chief Justice is here, learned judges are here, both the divisions. 116. We are most concerned with it because we in the bar also a part of the judiciary. Judiciary is very often described as a two-winged parts. One is bench, another is bar. Article 116 as it was in 1972 Constitution, I read it. The control, including the power of posting, promotion and grant of leave and discipline of persons employed in the judicial service and magistrates exercising judicial functions shall vest in the Supreme Court. And it is 72. 4th Amendment করে কি করা হলো? The control, including the power সবই রইল shall vest in the Supreme Court was substituted by the word president, shall vest in the president. By second proclamation order number 4 of 1978, in Article 116, the words and shall be exercised by him in consultation with the Supreme Court were added. খেয়াল করবেন, by second proclamation order 1978. আজকেই আমি পড়তেছিলাম, আগে পড়া আবার আজকে পড়তেছিলাম কোর্টে বসে বসে, আমার কোনো সুযোগ হচ্ছিল না বাংলা ধরার। কামিনী কুমার দত্ত মেমোরিয়াল লেকচার করছিলাম বাই লর্ড জাস্টিস মুস্তাফা কামাল। ওইখানে একটা কথা আছে যে irony of our history is that when elected political leaders abolished multi-party democratic system conforming to a pluralistic society, it is a general who brought back it. এখানে আর্টিকেল 116 এ হলো ভেস্ট ইন দ্য সুপ্রিম কোর্ট in 72. In after 4th Amendment, vest in the President. Second proclamation order 1978 এ করা হলো vest in the President and shall be exercised in consultation with the Supreme Court. 15th Amendment করে ওনারা বলছেন যে 15th Amendment এ they brought back the 1972 Constitution. No. Article 116 is in the Constitution as it was after second proclamation order. In 15th Amendment, Article 116 remained untouched and it is still as it was after second proclamation order number 4 of 1978. এই জায়গায় কোনো ছাড়াছাড়ি একই রকম তৈরি হয়। So the democratic character of the 1972 Constitution was totally destroyed by the Constitution 4th Amendment Act 1975, destroying multi-party parliamentary system, pluralistic character of a democratic society, election as an institution to ensure formation of representative government, destruction of a sovereign parliament as legislature of the republic, and at last but not the least, destruction of independence of judiciary. The government and political system introduced by the Constitution 4th Amendment Act 1975 were not durable and it met with the consequences as described. Thereafter military ruled for 2 terms and government formed through controlled elections, ruled Bangladesh for 1 decade and a half till fall of military dictator Hussein Mohammad Ershad through students' mass movement. In the face of victorious students' mass movement, when Hussein Mohammad Ershad was compelled to take decision to step down, though there was no provision in the constitution for election time non-party caretaker government at the relevant time, by consensus of the political parties, including two major parties, BNP and Awami League, an arrangement for election time non-party government with assignment to hold a free, fair and inclusive election was worked out in December 1990. Under this arrangement, the then Vice President Maudud Ahmed tendered resignation to President Ershad, on acceptance of which Ershad appointed Chief Justice Shahabuddin Ahmed as Vice President. Then President Ershad tendered his resignation to Vice President Justice Shahabuddin Ahmed, whereupon the Vice President became acting President under the provision of the Constitution. He appointed a council of advisors, and with the aid of the advisors, parliamentary election held in 1991, which is broadly accepted as a credible and fair election. Having won majority seats of parliament, BNP under the leadership of Begum Khaleda Zia formed government, and most importantly, according to consensus of the major political parties during unified movement against Ershad, the Parliament by Constitution 12th Amendment Act 1991 brought back the parliamentary system of government in Bangladesh Constitution. After a by-election in Magura, the opposition parties alleged massive rigging and refused to take part in any election under the government in power. And they boycotted the election of 6th Parliament, and in view of the movement, 6th Parliament in its session by Constitution 13th Amendment Act 1996, inserting Chapter 2 capital A in the Constitution, provided a non-party caretaker government for a limited period with assignment of routine work and with fundamental assignment of holding free, fair and inclusive election. Under such government, caretaker government, two elections were held, 96 and 1996 and 2001. In 1996, Awami League won and formed the government. 2001, BNP were voted to power and formed government. By the Constitution 14th Amendment Act, 13th Amendment Act, caretaker of 14th Amendment Act, retirement age of judges of the Supreme Court was made 67 years in the place of 65 years. And it was alleged very forcefully by Awami League and other opposition parties that it has been done with a view to have the present serving Chief Justice as Chief Advisor. Continue, Hartal, Ashojo. And at one stage, that at that time serving Chief Justice he retired, and he declared that he will not accept the office of Chief Advisor. But nothing could stop, and ultimately extra constitutional government came, headed by Probir. And that government held election in December 2008, election to 9th Parliament. In this election, Awami League got big majority in Parliament and formed government. The party in the government, in lieu of exercise of powers for implementation of election pledges made in manifesto and during election campaign, abused its big majority in parliament for perpetuation of power. The most important step to that end was abolishing non-party caretaker government, which was inserted in the constitution by 13th Amendment mainly on their demand. And significant amount of bloodshed occurred in the movement for non-party caretaker government. In Abdul Mannan Khan versus Bangladesh, by majority judgment, 13th Amendment was held to the ultra vires by the appellate division and declared void. 13th Amendment means non-party caretaker government. Subsequently, Parliament passed the Constitution 15th Amendment Act, repealing all the provisions relating to non-party caretaker government. Other provisions also were brought. Due to constraint of time, I will not go to that. One is the 7th clause. Some provisions have been incorporated and said these are unamendable, which could be done by a parliament. Can it be unamendable by another parliament? Whatever the intention was, since it has been made a part of the constitution, future parliament has to follow in bringing any change there. Article 142 of the constitution. A parliament cannot bind by its act a future parliament. That's just stupidity and foolishness in this area. So, by 15th Amendment, caretaker government gone, and the apprehension expressed by way of submissions by the majority, overwhelming majority of the amici curiae, out of 10 or 12, I can't remember exact number, except 2, all, even including the then Attorney General, they supported to keep intact provision for non-party caretaker government. The apprehension expressed by way of submissions by the overwhelming majority of the amici curiae have been proved to be true in the course of political events in Bangladesh subsequent to abolition of non-party caretaker government. In absence of non-party caretaker government as the most important ensuring factor of a free, fair and inclusive election, the so-called elections in 2014, 2018 and 2024 were neither free, nor fair, nor inclusive, and for that matter, no election in the eye of law and constitution. So there was no representative government. Sanctity and importance of voting right was described by Sir Winston Churchill in the following words, quote, "At the bottom of all tributes paid to democracy is the little man walking into a little booth with a little pencil, making a little cross on a little bit of paper. No amount of rhetoric or voluminous discussion can possibly diminish the overwhelming importance of the point." Unquote. Democracy is a misnomer unless the little man is allowed to express his view through voting. By introducing non-party caretaker government through 1996 and 2001 parliamentary election and also 2008 election, though under an extra-constitutional non-party government, Bangladesh was steadily attaining a stable parliamentary system, which was totally destroyed by abolition of non-party caretaker government by the 15th Amendment. Representative government is the spirit and basis of rule of law. In a true democracy, it is the free consent of the people that is ruled, people who are ruled, where the power of the rulers rooted in and sourced from. রুল অফ ল আমাদের আজকের যে আলোচ্য বিষয়, তার মূল কথাটি হলো the power of the rulers rooted in and sourced from the consent of the ruled, that is people, we the people. In view of Article 11 of the Constitution, fundamental illegitimacy of a government arises from the power without being voted to power. It is fundamentally illegitimate. Fundamental illegitimacy arises from the power without being voted to power. In that view of the matter, from 2014 till 5th August 2024, the government which ruled Bangladesh was illegitimate in terms of constitutionalism and spirit of rule of law. The fundamental features of such illegitimate government are totalitarian, autocratic and dictatorial, and for the government in Bangladesh from 2014 to 2024 was no exception. The care of human life and not happiness and not their destruction is the first and only object of a good government. An unelected government retaining power without being voted to power cannot have such object of a good government. Our contemporary history aptly and adequately prove these events. These events of July and first few days of August 2024 in Bangladesh made us understand what is meant by some scars never heal. These events made us realize that some days can never be forgotten. Some atrocities can never be forgiven. Excluded 9 months of our liberation war, our country has never suffered and witnessed such horrible atrocities of the power, so huge number of killings within such a short time. In those days, Bangladesh, what was stated by the power and what was believed by the people were totally different. Every person of common prudence could realize the universal truth that time. Change is the only constant, and it proved to be true. The government, like all totalitarian and autocratic governments of the history, kept no avenue open for their peaceful removal. And accordingly it claimed hundreds of lives and sacrifices to a great extent for its removal through students' mass uprising. As a nation, Bangladesh was put to a backward motion of history by abolition of non-party caretaker government, consequence of which was the abolition of representative government, rule of law and democracy, abolition of fundamental rights enshrined in Part 3 of the Constitution. A number of reformative steps have to be undertaken. But the first and foremost task is to bring back the provision of non-party caretaker government in the Constitution, to bring back Bangladesh into the track of democracy and rule of law. The politicians aspiring to be elected in the next parliament must be committed to the nation to bring back the provisions of non-party caretaker government in the Constitution. The present interim government, as the outcome of the people's will expressed through the victorious July uprising, has to play the role of non-party caretaker government as an extra constitutional measure like 1990 and 2008 for holding a free, fair and inclusive election for the constitution of the next parliament. Extra constitutional for that limited purpose as caretaker government for holding a free, fair and inclusive election. Eta interim government এই ভূমিকাটা তারা পালন করতে হবে। There is a saying, a nation gets the government it deserves. Thomas Jefferson once said, the government you elect is the government you deserve. True, after abolition of non-party caretaker government, our people could not elect. After the political changeover and all of unelected totalitarian and autocratic government, the people as members of the nation have the duty to play their role in getting back the right to elect and also to be elected. Right to elect and to be elected. It is the awareness, vigilance and political consciousness of the people which is the most effective safeguard to ensure that the interim government and the political parties will act in direction to achieve the dream of the people for a democratic Bangladesh. We, particularly in our rank, in literate middle class, lack in this regard, self-criticism. I like to conclude borrowing words from Bertolt Brecht, as I have no better words of my own. Quote, the worst illiterate is the political illiterate. He doesn't hear, doesn't speak, nor participate in the political events. He doesn't know the cost of life, the price of the bean, of the fish, of the flower, of the rent, of the shoes, and of the medicine. All depend on political decisions. The political illiterate is so stupid that he is proud and swells his chest, saying that he hates politics. The imbecile doesn't know that from his political ignorance is born the prostitute, the abandoned child, and the worst thieves of all, the bad politician, corrupted and flunky of the national and multinational companies. Unquote. So, I am grateful to all for giving me a very, very patient hearing, and what I said at the beginning, I will repeat that, reiterate that write-up or writing is not worth reading, which leaves no room for its readers to read between the lines and beyond the lines. And I know you are very competent, able, brilliant readers. You will read undoubtedly many things between the lines and beyond the lines. I am grateful to everybody. Thanks to everyone.